Hey everyone, welcome back to my channel. I'm going to take some time and give you some updates today on everything that's happened since my arrest. Don't expect to see my face much. I'm just sitting out here in my yard enjoying the afternoon. For reference, I will show my face. I am the same guy that made the video. In my video history you can find about COVID. But again, this video isn't about me, it's about the law. So I have prepared some notes. I'm going to be taking time today to read a lot of things to you, to talk about the relevant case law and how it applies here. I'm excited to give you these updates on my legal situation, and I want to take the opportunity to give everybody some critical education on our rights in situations like these. If you've watched my previous videos, you know I'm facing charges after what I consider to be a blatantly unconstitutional stop and escalation by Covington County deputies. So here's a rundown of everything that's happened since that day, and I'll go over the motions I filed and some of the big legal precedents that I have found along the way. So on October 15th, 2024, which was the day I was stopped, I was about 1:20 in the afternoon. I was driving alone on a pretty empty road and came up to a county roadblock. As I pulled into the roadblock, I questioned the deputy that met me at my door. I said, "What's the purpose of the stop?" And they said, we're checking licenses." So I complied. I showed them my license and my insurance, which they didn't ask for. And instead of them just returning my license and sending me on my way, things started to get odd. They started questioning me on where I was going, where I was coming from, where I work. I chose to not answer these personal questions. I told them simply, I don't answer questions. Of course, that escalated the situation. They met at my tailgate of my truck. I overheard them questioning my answers to their questions, talking among themselves, saying things like, "Well, I've asked him where he's going, who he works for. He just kept telling me he doesn't answer questions." And I heard another one say, "Well, I tried to talk to him and I asked him why was he being defensive, and he told me he doesn't answer questions." And after I heard a little bit of this going back and forth, they decided to approach me and from the rear of my vehicle. And at that time is when I started the recording. So when I realized they were fishing for something, and then they cited Pennsylvania v. Mims, saying it gave them authority to remove me from my vehicle. Okay. Now, at the time, I didn't know what that was, but I've done some research, and I've learned that case does let officers ask you to step out of a vehicle if they feel there's a safety issue, but it doesn't let them extend a stop without reasonable suspicion. This was about intimidation and overreach, not safety. Now, the whole interaction was strange. At one point, they contradicted themselves by saying my eyes were both dilated and pinpoint in the same paragraph. Despite my offer to take a breathalyzer or blood test, Mississippi law requires that for actual DUI suspicion, and it also is a part of the implied consent law that any motorist is taken to have given implied consent for a breathalyzer, alcohol test, or a blood or urine sample as a driver. Refusal to take such tests do carry consequences, but there is no legal requirement in Mississippi for any motorist to submit to a field sobriety test. And we're going to cover these things and more later in the video. So, they continue to insist on a field sobriety test, and at one point even tried to coerce me and said, if you do the field sobriety, we'll let you go. They ended up charging me with disorderly conduct, which everyone has seen here in video 2. Once at the jail, things didn't get better. We're going to go into a lot of that, but they took about 3 hours to even process me to the point where I could make a phone call. I almost ended up paying for an overnight towing fee and possibly other expenses. Simply because the tow yards there on there close at 5 p.m. and from the time that they got me to the jail, which was right at about 2 o'clock, to the time that I was allowed to make a phone call was about 20 minutes until 5. And they would not allow me to make a phone call until after they had dressed me out into jail clothing, fingerprinted me, photographed me, and formally booked me. Um, all of that took, like I said, over 3 hours to complete. It was a bit of a strange situation to me. So, but anyways, I'm challenging these charges in court on multiple grounds. I've filed motions to dismiss based on constitutional violations. I'm going to cover those today, and I'm going to show documentation here on the video screen. I've filed motions to suppress any evidence gathered after they unlawfully extended the stop. I have requested all public records, body cam footage, police reports, and dash cam footage from that day to expose any inconsistencies and procedural errors, as well as to capture the first few minutes of the initial interaction that I do not have recorded on my phone. One case that really bolsters my arguments is the City of Indianapolis v. Edmond. This is a case from 2000, and the Supreme Court ruled that law enforcement can't use roadblocks to randomly check for crimes, but only for specific limited purposes, like checking licenses or stopping DUIs. In fact, a recent 2022 case in Mississippi, where the city of Jackson was sued, resulted in the city agreeing to stop using roadblocks for general crime control. These cases make it clear that what happened to me, deputies using a license checkpoint to dig for other crimes, is a violation of the Fourth Amendment. Our rights aren't there just for decoration. They're meant to be honored. And this case has real potential to raise awareness and maybe even change practices in how these stops are handled here in Mississippi. So, I'm going to take the time and let all of you know what I'm doing here, because it's important that you know your rights, and it's important that you stand up for your rights. One of the most important rights that we should always remember is our constitutional right to remain silent. And that's what started this entire affair. I'm going to put the camera on me for a little while. But that's what started this entire affair. The deputies did not like that I did not want to participate in their games and answer their questions, and decided to bully me to manufacture probable cause to try to justify a means to arrest me. This is not an isolated incident. It's an actually common occurrence. I've seen in the comments where people have said that one gentleman has stated that he actually lives in Covington County. This doesn't surprise me at all. It is actually a pretty common practice, I'm pretty sure, in many other places. There was an incident last year where I was traveling at about 2 o'clock in the morning with my family, and I went through a sheriff's roadblock and was actually snatched out of my vehicle and placed into handcuffs, and they insinuated and pretty much almost outright called me a child trafficker, insinuated that my wife, daughter-in-law, and my grandchild, my grandson, were being human trafficked by me, and went so far as to tell me that, we really have to be careful out here, and your attitude with us caused us to think that there was something not going on right. There was no attitude. I rode through the roadblock. They asked me the questions. I told them I don't answer questions. They let me go. I went home that night, but this case was different. They decided that, their right to stop and detain me beyond the initial scope of the interaction was lawful, but apparently was not. So I've got some motions here that I filed. I'm going to go over them with you guys and then let you see what I've done. I did find out that My court cases are scheduled for January 15th. And it's odd to me that they put it that far out. Well, initially my hearing was set for November 27th. And when I contacted the Justice Court, they told me that this is just a contact by date. And when I contacted them, which was before that date, of course, they told me that I don't even have a case number yet, that I've got to be arraigned and indicted before a grand jury before I even get a case number. So I went ahead and I filed these motions. I'm trying to be really preemptive and proactive here to get this done and over with. I don't have time to be waiting around until January, but they did tell me that the January date is a plea date. I don't know. So, I got some notes here. I'm going to go over them with you guys. I did send to the court's physical address and to the court's P.O. box by certified mail these motions, as well as I sent copies of my motions to the prosecutor. That's a process that is required in any legal matter. The defense and prosecution have to provide each other with copies of all motions filed with the courts. Starting here with the public records request, I'm going to show this in the camera. You can see here that I have requested, pursuant to Mississippi Code annotated 25-61-1, all body camera footage from the deputies involved in my stop, detention, and arrest, the police report, notes, incident reports, and supplementary documentation. I want the results of the urinalysis I provided in the jail, and I want the dash cam footage. Now, there aren't any 911 or dispatch logs other than the call when Sergeant Summerlin called in that he was going to be bringing me in. Now, according to law, they have 7 business days to reply to me and my request. And if they are unable to provide the information, then they will be forced to give me an explanation for such. I think I just flipped my screen all kind of crazy, and I do apologize for that. I am not a professional videographer. I am not a professional blogger. I am a common man, and I am also sick and tired of my rights being trampled on. I'm sick and tired of police officers and police agencies thinking they can just run over citizens' rights as they please and do it without consequence. So I started learning my rights, and I started learning the law, because the only way that you're going to stand up to bullies like this is by knowing your law and refusing to be silent. I'm all over the place with this. Back to your right to remain silent. That is one of the perhaps single most important rights that you should always adhere to. However, when I went into this roadblock armed with the knowledge that I was probably going to get arrested. I do this every time I go into a roadblock. I go into the roadblock with the knowledge that I may get arrested, because many officers do not like being told I don't answer questions. And they will manufacture probable cause to arrest you. And doing so in Mississippi seems to be very easy to do. It all depends on who you run across. Now, this is the first time I've actually been arrested and taken to jail unlawfully. And I'm glad that I documented this and got it all on tape, because this will not end after I get the charges dismissed. So the motion that I filed, I'm going to read along here with you. I'm going to show you here. It's a pretty lengthy motion. It is altogether 4 pages. On the 4th page, I provide documentation showing the actual video evidence for the judge to review, so that they can actually look on my own YouTube channel and see the evidence without even having to request the body cam footage. But the body cam footage and dash cam footage is going to corroborate further all of my allegations here. So, at any rate, let me get to this. All right, so I'm going to take the time now, and I'm going to read all of this to you guys, and I want you to take along and understand that I'm also going to put notes on a online share, so that if you are facing any of these things yourself, unlawful stops, that this is all information that is good to know. Perhaps if you're up for the challenge, write some of these legal precedents and case law down on note cards, index cards, put them in your glove box, keep them handy, know your rights, be able to quote law. If they come at you and give in falsely or misapply a legal precedent, as Sergeant Summerler did with Pennsylvania v. Mims, know that you can rebut that and tell. I wish I had known the case law in my mind, and I would have enjoyed arguing with that man, honestly. But in the event that you don't really know your rights, the best is to remain silent, which I did. And I began to engage and argue with them when I realized no matter what I said, I was going to go to jail. So I was going to document all of it. And here we are today. In the Justice Court of Covington County, Mississippi, comes now the defendant, me, by and through himself, and respectfully moves this court to 1, dismiss the DUI charge. I'm not going to hold this phone up like this all this time. I'm going to set this phone down, but I'm going to read this to you guys, so listen to me and bear this out. By and through himself, and respectfully moves this court to 1, dismiss the DUI charge on grounds of lack of legal basis and constitutional violations, and 2, dismiss the disorderly conduct charge on similar grounds, and 3, suppress any evidence obtained during the unlawful extension of the stop. In support of this motion, the defendant states as follows. Section 1, Facts and Backgrounds. 1. On October 15, 2024, at approximately 1:20 p.m., the defendant was stopped at a roadblock conducted by the Covington County Sheriff's Office. The stated purpose of the roadblock was to check for valid driver's licenses. At the time of the initial stop, the defendant was the only vehicle on the road. Upon being stopped, the defendant provided his valid driver's license and insurance promptly. Fully complying with the legal requirements. 2. Despite this compliance, deputies, including Sergeant Josh Summerlin, began questioning the defendant on unrelated matters such as where are you going and where do you work. The defendant exercised his constitutional right to refrain from answering these questions about his origination, destination, and place of work. This refusal to engage led to an escalation, where deputies then sought to manufacture probable cause to justify an extended stop. 3. During the illegal extension of the stop, several other vehicles were allowed to pass through the roadblock after cursory inspections of their licenses, as noted in the defendant's video at approximately 4:36 of Exhibit A, Part 2. This selective and prolonged detention of the defendant, while other drivers were allowed to pass, indicates a targeted and unjustified action against him, inconsistent with the roadblock's stated purpose of checking licenses. 4. Sergeant Summerlin improperly cited Pennsylvania v. Mims as legal authority to justify to justify extending the detention and attempting to coerce the defendant into performing a field sobriety test. Mims permits officers to ask a driver to exit the vehicle for safety reasons, but does not justify further investigative actions without reasonable suspicion. The sergeant's misrepresentation of this case law highlights a misuse of authority and an attempt to coerce the defendant under a misapplied legal precedent. 5. At approximately 6 minutes 10 seconds in Exhibit A, Part 2, Sergeant Summerlin can be heard stating, "We are not out here just looking for people with no driver's license. We are enforcing traffic law." This admission reveals mission creep and indicates that the purpose of the stop was unlawfully extended from checking licenses to broader enforcement, in violation of City and Indianapolis v. Edmond. Edmond established that roadblocks with the primary purpose of general crime control, rather than specific limited purposes such as checking licenses or sobriety, are unconstitutional. 6. Throughout the encounter, Sergeant Summerlin and other deputies made conflicting and inconsistent observations about the defendant's physical state. Initially, the sergeant claimed the defendant's eyes were dilated, but later stated they were pinpoint. Despite these contradictory observations, the sergeant proceeded to accuse the defendant of being under the influence of other substances without offering specific, articulable facts to support this suspicion. When the defendant asked what substances were being referenced, the sergeant speculated about a range of drugs, including cocaine, methamphetamine, pills, and heroin. 7. The defendant was ordered to exit the vehicle and submit to a field sobriety test, which he declined. The defendant instead offered to comply with Mississippi's implied consent law by submitting to a breathalyzer or blood test, a lawful means of determining impairment. Sergeant Summerlin refused this and insisted on the field sobriety test, stating, "I can only suggest it." During this period, one deputy falsely assured the defendant that he would be allowed to leave if he simply performed a field sobriety test, stating, "We will let you go if you just do a field sobriety." Exhibit A, Part 2, 5 minutes 15 seconds. This deceptive tactic, designed to coerce compliance, further exemplifies the deputy's inappropriate conduct and disregard for the defendant's rights. I got glare from the sun coming down on me now. 8. The defendant was subjected to several threatening comments by deputies, including, "We can and will snatch you out of that truck." These remarks created a coercive and intimidating environment, which may have led to involuntary compliance. Such conduct represents a violation of the defendant's constitutional protections against unreasonable searches and seizures. 9. The defendant was subsequently placed in handcuffs and informed he was being charged with disorderly conduct. It was only after being processed at the jail that he learned he was also being charged with DUI, other substances. Under Mississippi Code 63-11-23, when a driver is charged with DUI, the arresting officer, check this out, when a driver is charged with DUI, the arresting officer is required to confiscate the driver's license, and the ticket or citation issued serves as a temporary license until the court date. However, the defendant's driver's license was improperly returned upon release. Yes, they gave me my license back. And the summons ticket for the DUI was not provided to the defendant. No, they did not give it to me until after I specifically requested clarification on my court dates, at which point the jail staff produced the ticket and admitted it had been forgotten. These procedural deviations raise serious concerns about the legitimacy of the arrest and due process violations. 10. The defendant has since been informed by Justice Court Clerk Paula that the date on the ticket is not a court date, but rather a contact by date for plea negotiations. The actual court date is set for January 15th, 2025. This inconsistency, along with the mishandling of documentation, undermines the credibility of the charges and suggests procedural irregularities. The misleading instructions may have caused the defendant irreparable harm, leading to potential undue legal consequences for failure to appear based on inconsistent and unfamiliar processes. Section 2. Motion to dismiss DUI charge. The defendant moves to dismiss the DUI charge based on the fact that the charge stems from an unlawful and extended stop which violated the defendant's Fourth Amendment rights. According to Rodriguez v. United States, law enforcement officers cannot extend a stop beyond its original purpose, in this case checking driver's licenses, without reasonable suspicion. The deputy's actions, as evidenced by the video recordings, were aimed at prolonging the stop without articulable facts to justify reasonable suspicion, rendering the detention and subsequent charges unlawful. 12. The selected and extended detention of the defendant, while other vehicles were permitted to pass through after brief inspections, further demonstrates that the actions of law enforcement were unjustified, arbitrary, and aimed at coercing the defendant. The United States Supreme Court has ruled in Delaware v. Prowse that discretionary stops without a reasonable, individualized suspicion are unconstitutional. The sergeant's actions were inconsistent with this principle, and any evidence derived from the unlawful detention should be inadmissible. Section 3. Motion to dismiss the disorderly conduct charge. The disorderly conduct charge is based on the defendant's refusal to comply with the sergeant's suggestion to take a field sobriety test. However, Mississippi law does not require drivers to submit to field sobriety tests, and refusal to take one does not constitute any violation of any law. The defendant's willingness to take a chemical test as required under Mississippi's implied consent law demonstrates his compliance with lawful procedures. 14. The defendant's video recording, saved as Exhibit A, captures Sergeant Summerlin's improper citation of Pennsylvania v. Mims, highlighting a misrepresentation of case law to justify extending the stop without legal basis. The recording further shows the defendant's clear statement that he was willing to comply with any lawful order, including a breathalyzer or blood test. 15. Under Mississippi Code 97-35-7, disorderly conduct must involve behavior that intentionally or recklessly causes a public disturbance or failure to comply with a lawful order. The defendant's refusal to perform a field sobriety test, which he was not legally obligated to take, does not fit this description, and his arrest on this basis is without merit. Furthermore, the deputy's actions to prolong the stop violated the principles established in Rodriguez v. United States, and thus any resulting charges are similarly flawed. Section 4. Motion to suppress evidence. 16. The defendant moves to suppress any evidence related to the DUI and disorderly conduct charges on the grounds that it was obtained through an unlawful extension of the stop. As established in Rodriguez and reaffirmed in Prowse, law enforcement officers cannot extend a stop beyond its original purpose without reasonable suspicion. Sergeant Summerlin's actions in questioning the defendant and pressuring him to take a field sobriety test without specific articulable suspicion of impairment violated this principle. 17. The defendant's video recordings, Exhibit A, capture the coercive tactics used by the sergeant, including conflicting statements, improper citation of legal precedent, and attempts to prolong the encounter. Such tactics, without legal justification, warrant the suppression of any evidence that may have been attained as a result of this unlawful detention. This includes, but is not limited to, officers' observations, notes, police reports, urinalysis results, defendant statements, body cam footage, or any other evidence obtained by means of unlawful search and seizure. Section 5, Exhibits. Now you'll see here that I have actually placed clickable links if they are reading this in an online version through Microsoft Word or Adobe PDF. I believe it's a PDF version that is available online. But they can also type these links into a browser to be able to view the evidence. And conclusion, number 18. For the reasons stated above, the defendant respectfully requests that this court dismiss the DUI and disorderly conduct charges, as they are without legal basis, violate the defendant's constitutional rights, and were processed without significant procedural irregularities. The defendant further requests, they were processed with significant procedural irregularities. The defendant further requests that this court suppress any evidence related to these charges, including but not limited to officers' observations, notes, police reports, urinalysis results, defendant statements, body cam, or other evidence obtained by means of unlawful search and seizure, as it was obtained through coercion and an unlawful extension of the stop. So, with that being said, I knew rolling into that stop that I had potential to go to jail that day. I had done enough research and homework to know and understand the restraints that are placed upon law enforcement during these roadblocks and checkpoints, and what they can and can't do. What they can and will do are two different things than what they are often allowed to do. And as such, having a dash cam or a phone handy to record any such encounters is always a great idea for your safety. So, what I've got here, and I'm really not going to, keep all of you glued to the screen this long. This video is already about 30 minutes in. This is a lot of the legal merits, objective analysis, and applicable statutes and case law as it relates to my case. It's a lot of my notes that I have made and how I can use this information to help me in my case. For example, this one here, you'll see the prolongation of the stop without reasonable suspicion may constitute a violation of Freeman's Fourth Amendment rights. As cited in Rodriguez v. United States, any detention beyond the purpose of the original stop, checking driver's licenses, must be based on specific articulable suspicion of criminal activity. The failure to establish such a basis can lead to suppression of evidence in the criminal case and form a claim in civil court. Okay? So, this is, things like this are important elements that are going to be beneficial to me in my case, as well as to provide information to you guys, the general public, my subscriber base, and anybody that happens to come across this video, for information that will help you to better defend yourself against tyrants and bullies and badges. So, I'm going to tell you what, AI, especially any AI that you pay for, is very useful in doing research. So, I ran a bunch of things through some AI, and I want to share this with you. Based on the detailed analysis of my case, the following assessment highlights the merits and values of both the criminal and potential civil proceedings. It also outlines the next steps for advancing the case effectively in both forms. The reason I'm sharing this with you is because a lot of you have expressed a request for updates to know more about what's going on. So, what's going on is I've already filed the motions, and now I just gotta wait to hear back from the courts and get a date to hear the motion, and to give the prosecution time to reply and either agree with or rebut my motion. So in this next section here, I develop a strong outline for myself to reference the different points. One being strong constitutional arguments against prolonged detention. Two being procedural missteps by law enforcement. Three being evidentiary issues and motions to suppress. Additionally, I cover such things as the case merits and values, including the coercive tactics, threats, and intimidation used by the deputies, violating my Fourth Amendment rights, as well as their continued persistence in questioning me after I had repeatedly asserted my Fifth Amendment right, can also be evidence of a violation of my Fifth Amendment right. There is the misapplication of legal standards and abuse of authority to consider, procedural failures and due process claims, as well as some general next steps that I'm going to be proceeding with here. Okay? A lot of this is things that I've already done as far as filing for motions for discovery with the officer of the court records. And I have here a outline of the relevant case law and statutes, as well as their legal citations, with with a brief synopsis and explanation of each of these rulings as they've been handed down from the higher courts. We've got Rodriguez v. United States, which we've discussed here a couple times. City of Indianapolis v. Edmond, Delaware v. Prowse, and Pennsylvania v. Mims. I've also got McNeely v. Missouri. Then there is the Mississippi Code 6311-23 DUI procedures, Mississippi Code 97-35-7 disorderly conduct. This is relevant to my case in particular, but it will be available online in a link that I'll share in the description for your review to be able to know what applicable statutes and laws there are to help you protect yourself. I've also got here another summary. This one includes Illinois versus Cabales. And in this one, the Supreme Court held that a lawful traffic stop can be extended to allow for a dog sniff if the extension does not reasonably prolong the stop. The dog sniff itself was deemed non-intrusive and did not require reasonable suspicion as long as it did not lengthen the stop's duration beyond the time needed to address the original purpose. The legal definition and scope here is the key aspect of Cabales is that any unrelated investigation during a stop, such as a dog sniff for drugs, must not extend the duration of the stop. The original purpose of the stop must be completed promptly. And how is it relevant to my case? Because it was an unlawful extension. They expanded the stop beyond the initial purpose of a license check without clear cause, similar to how a dog sniff in Cabales would be unjustified if it prolonged the stop without reasonable suspicion. The deputy's mission creep from license check to impairment suspicion without articulable facts supporting the change mirrors the addresses addressed in Cabales, underscoring that my stop may have been unlawfully extended. There's additionally Mississippi v. Weatherspoon, another traffic stop law, the Mississippi Implied Consent Law, which I was in full compliance with, its legal requirements and limitations, and a brief summary of how these are applicable to my case. And then I have Terry v. Ohio. Terry v. Ohio is from 1968, and it's foundational to this. This here will also be available online in my Dropbox. I encourage you all to use these online references that I'm going to provide for you here and use them to know your rights seriously. This is a constitutional republic and we are built upon law. And when law enforcement doesn't know the law themselves, and you have to learn the law to protect yourself. So, I hope that all of you find the information in this here useful. I want to thank you all for taking the time to return to my channel and follow along for this update. I'm looking forward to what's going to come out of this, seriously. I'm waiting to hear back from the courts right now. The notice of service that I received right here is for the Covington County Justice Court clerk. I sent copies to the P.O. Box and to the physical address. That is for the physical address notice of service. There was also the court records officer that I sent the public records request too. I have not received my return receipt for that yet, as well as the prosecutor. I sent him copies of the motions, and I have not received my return receipt yet. And there was also other things. I lost my train of thought for a moment. My dog came by me, but look, guys, seriously, I have another channel that's dedicated to gaming, and I thought about sharing that there, but I didn't want to because this is, real life here. And I would like all of you to like the video and subscribe and share and leave a comment, please. I'm not looking for monetization or anything like that. I mean, we all know, yeah, this is YouTube, just a great big internet. Things like that happen. But I really just want to, use this opportunity, this experience here to share with others and, empower us as people to stand up to tyranny and to not be bullied. And again, the entire reason I started on this journey of learning my rights to begin with was because I got tired of being bullied. Who knows what's going to come out of this? I do know that once these charges are defeated criminally, that there are civil options for me. It would be nice to find the assistance of a major law firm that would be interested in considering this as a case to potentially create reform. Reform is severely needed. Um, there could also be monetary implications. So, again, thank you all, guys. Again, please like, subscribe, share with your friends, comment. It all helps the algorithm. Um, for the rest of everybody out there, just have a great day, and look forward to bringing you more updates soon.